No, I'm fine with that. I just want to make sure that the public can see me if they need to. Might not want to. I am. Do you want to take one of these and then get one from the new one?
That's okay. I saw that. Somebody's computer. Yeah. Oh, yeah.
Art, look out.
Do you want me to just...
Yeah.
But then I don't have my back. With Alex.
Oh, wait.
It might be better. That's okay.
Yeah. Okay, good.
That's fine. Okay, would everybody please rise and join me in the Pledge of Allegiance? I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Pursuant to Section 5, Chapter 231, Public Laws of 1975, this is to state for the record that adequate notice of this meeting has been provided to the public by posting and maintaining the annual notice of the regular meetings on the bulletin board in the municipal building, and by providing a copy of the annual notice of the regular meetings for the year 2016 to the Glen Ridge paper, the Glen Ridge Voice, the Montclair Times, and to the Star Ledger on Tuesday, January 5th, 2016, and by filing said notice in the office of the municipal clerk. Will the clerk please call the roll?
Councilperson Hughes.
Present.
Sovich.
Here.
Leftwich.
Here.
Dawson.
Here.
Murphy.
Here.
Morrow.
Here.
Mayor Patrick's present. Mr. Mayor, you have a quorum.
Thank you, Michael. May I have a motion to approve the minutes of the last meeting of November 28, 2015?
So moved.
Second?
I'll second that.
Thank you, Mike. Thank you, Dan. You've heard the motion. Will you please call the roll?
Councilperson Hughes.
Aye.
Sovich.
Aye.
Leftwich.
Aye.
Dawson.
Aye.
Murphy.
Aye.
Morrow.
Aye.
6 ayes, no nays. The motion is carried.
Do we have any written
Yes, we do,
communications?
Mr. Mayor. We have a memo from the New Jersey Housing and Mortgage Finance Agency regarding public service promotion of funding and foreclosure prevention application. And then we also received the executed contract from Public Alliance Insurance Coverage Fund for the 2017 trust renewal.
Please stand for correspondence.
Correspondence.
At this time, we're going to suspend the regular order of business for a presentation by our court-appointed special master, Elizabeth McKenzie. Ms. McKenzie, the floor is yours.
Yes, thank you, Mayor. Can everybody hear me? I'm pretty loud. I usually wake babies. I'm here tonight. I was asked to come to explain and provide some background and a sort of a status update regarding the builder's remedy litigation in which Glen Ridge finds itself, and to tell you first how that came about and why there's that kind of litigation, and then sort of what your options are as you deal with that litigation. I have seen the really excellent letter that John Maliska, your municipal attorney, prepared, and it was on your website. I don't know if all of you had a chance to review that, and so I won't give you the, all of the chronology that's in there. It's really an excellent analysis, but I will just start by saying that, the Supreme Court of New Jersey has for a long time taken the position that the power to zone comes with a constitutional obligation to zone for all people in the state of New Jersey, and that, and initially in 1975, the Supreme Court decided the Mount Laurel I decision, which basically said to municipalities, you have to provide for a variety and choice of housing, and, including apartments and townhouses and things of that nature. That mandate failed to produce housing that was actually affordable to low and moderate income households. Some towns, and I know a lot of examples of this, some towns would take their worst land and just zone it for apartments, and of course nobody wanted to build it. And other towns actually got construction of apartments and townhouses, but they were all luxury apartments and townhouses that didn't have any units that were affordable to low and moderate income households. So in 1983, after there were several lower court decisions, and appellate decisions, but in 1983, the Supreme Court again decided what became known as the Mount Laurel II decision, and basically said to towns, okay, enough. We didn't get what we were expecting to get. So from now on, we are going to say that that all towns have an obligation to provide their fair share of the low and moderate income housing needs within the region. And they sort of gave a suggestion for how that fair share should be determined. It was back in the old days, so I'm old enough to remember all this. There was something called the State Development Guide Plan, which had growth areas and non-growth areas, and so there were different rules for all of those parts of the state. But in any case, they suggested a potential way to do this. Later, a more formal methodology was developed by Judge Serpentelli in the AMG versus Warren Township decision, and a lot of other municipalities, representatives joined in coming up with that methodology. And basically a way to determine affordable housing obligations began to be used, and municipalities got sued by developers. And under Mount Laurel II, the court said, if you're not in compliance, and the developer can prove that you're not in compliance, that you're not dealing with your fair share, and if the developer is proposing a substantial number of affordable housing units, he gets a builder's remedy. And they provided a mechanism by which the courts that were hearing these cases could appoint masters to assist in determining what the proper builder's remedy should be and in confirming what the town's obligation would be. So that's the origin of all of this. And then, in the onslaught of builder's remedy filings that came right after the Supreme Court's decision in 1983. In 1985, the legislature woke up and said, wait, we got to do something about this because, towns are not very happy with us, that they're kind of wide open on this. So they adopted the Fair Housing Act. And in the Fair Housing Act, they made provision for the establishment of the Council on Affordable Housing. And the Council on Affordable Housing was empowered by the Fair Housing Act to make all of the, calculations as to what municipal fair share obligations would be, and then towns could voluntarily submit their plans to the Council on Affordable Housing and get something called substantive certification. And that worked really well from 1986 through 1999. And in 1999, COA was supposed to adopt brand-new rules for the third round. They had the first and the second rounds. And in fact, Glen Ridge participated in the first round, submitted a plan to the Council on Affordable Housing, was determined to have an obligation that was bigger than they could actually meet in town because you didn't have any vacant land. You still don't have vacant land. But it was determined that the obligation would be adjusted by way of a vacant land adjustment, which is something that COA covers in its rules. And so your obligation was reduced to 25, and the golf course property, the front of the golf course property, which is in Glen Ridge, was zoned to potentially accommodate 25 affordable units along with market rate residential units. That has never developed, and it has never happened. So in any case, when round two came around, the first and second rounds were sort of consolidated. Your number went from 25, it went up to 28. But there was, since there was still no way to meet anymore, the town didn't want to spend the money going through that process, and understandably so. And then in the third round, COA couldn't get it. It tried a new approach to determining affordable housing obligations called a growth share approach, which is saying, if you grow, you have to provide affordable housing. And, the courts didn't like the way that was written because it allowed towns to determine how much they would grow and thereby exclude poor people. So COA modified its rule. The appellate division threw out COA's 2004 rules, and then new rules were published in 2008, and they were amended and readopted later on in 2008. And those rules were thrown out by the appellate court, and then COA seemed to not be able to get it together to adopt new rules. So what happened was there were appellate court decisions, and then finally the Supreme Court stepped in 2013 and said, hey, if you're not going to do this, you have to comply. You have to adopt new rules, and they gave COA a deadline. And COA missed the deadline and asked for additional time. The Supreme Court gave COA additional time. Still didn't happen. Finally, in 2014, COA came up with new rules, and there were lots of comments on those rules. And in the end, COA was deadlocked 3-3 and did not adopt the rules. Now, there were a lot of other things going on in the background. The governor had pledged in his campaign to eliminate the Council on Affordable Housing, to eliminate COA, and effectively, even though the Supreme Court told him he couldn't do so, he managed to do it administratively by simply reassigning COA staff to other offices. So if COA wasn't, even the 2014 rules that were prepared weren't prepared by the traditional COA staff. They were really prepared by people working for the governor's office. So in any case, COA deadlocked on adopting the rules. The Supreme Court, there was an order to show cause. The Supreme Court basically said, well, are you planning on having another hearing to adopt new rules? And the state's representative said no. So the Supreme Court in March of 2015 said, okay, COA is basically a defunct agency. We're taking it back. We don't want the towns that had been before COA and thinking that COA would, evaluate their plans and grant them certification. We don't want them to be open to builders' remedy lawsuits. So we will allow them to file. First of all, we'll stay the effect of our decision for something like, it was like four months or something, or 3 months, on purpose to allow COA the opportunity to adopt new rules or to allow the legislature to step in and make some amendments that would do something, but nobody did it. So it really left towns in a pretty bad position. But in any case, the Supreme Court did allow towns to that were before COA or had already gotten third-round substantive certification under the rules that got invalidated. They allowed them to come back in and file declaratory judgment actions and get the court to sort of approve their plans without necessarily having that motivated by, excuse me, by a builder. In Glen Ridge's case, because Glen Ridge had no vacant land, Glen Ridge had not been before COA in the third round, was sort of waiting out to see what would happen, which, you know, in Glen Ridge's case was actually made some sense. But, and I'll explain why in a moment. But in any case, they unfortunately got, during that whole interim process, a developer came in, assembled some parcels that the owner was getting ready to sell, and came in and filed a builder's remedy lawsuit against Glen Ridge. So in that builder's remedy lawsuit, there is a presumption that if the developer is going to propose a development that provides a substantial amount of affordable housing, he will get a builder's remedy. I mean, something will go on that site. And Judge Carey got the case initially and appointed me as the master. That case has now been reassigned to Judge Gardner, who has given Glen Ridge the courtesy of allowing them to participate with the other towns that are before the courts in the declaratory judgment actions as to the determination of numbers and, you know, to have a seat at the table for, you know, all of that sort of regional discussion of numbers. But basically, Glen Ridge is positioned a little differently from the other towns because the other towns may have interveners, but the interveners don't have any particular rights in terms of the developments of their sites. They may end up being included in the plans, and it depends on each individual town as to whether they are or not. But in Glen Ridge's case, you have a developer that has filed a builder's remedy lawsuit. You don't have any other alternatives for meeting your obligation, and no matter how large or small your obligation is, you won't be able to meet it. You will still have a vacant land adjustment. I mean, that will continue. But the builder will get a builder's remedy. And the question is, and there's been, you know, obviously there have been mediation sessions that I have held to try to see if we could come to some sort of agreement and resolve this. There's no agreement at this point. But the purpose of those mediation sessions is to see if we can't get a substantial development that provides a lot of affordable housing, but also, you know, is respectful of the concerns of Glen Ridge with respect to, you know, design issues and traffic issues and things like that. And all of those are on the table and are in the process of being discussed. And the developer hasn't been uncooperative. He's been interested in talking to the town, and the town has been gracious. I think everybody has conducted themselves really nicely. But there still is not a settlement yet, and there won't be until the council decides, you know, we think this is reasonable to take public, and we're going to have, you know, a hearing on it, and that hasn't happened yet. So, but we are in that process of trying to work that out. Meanwhile, in all of the cases in Essex County and every place else in the state, there is a public housing advocate called Fair Share Housing Center that has that is out there and has been establishing you know, their numbers, putting forth their numbers for towns, and their numbers are higher than the expert that Glen Ridge hired, which is eConsult, which has much lower numbers. And then there's another expert out there in the state that has not been hired in Essex County, but has been hired in other counties, and his numbers are sort of in the middle between the numbers that eConsult has come up with and the numbers that Fair Share Housing Center has come up with. I got to say that to some extent in Glen Ridge, it doesn't make any difference. I mean, your number will be more than you can handle no matter who comes up with the number. You will get a vacant land adjustment. That's unquestionably so. Your planner has done a very thorough analysis of what the opportunities are in Glen Ridge, and they're really, other than this particular site and the golf course site, if it ever redevelops, which it doesn't appear to be in any hurry to do, are pretty much your only opportunities that are on the horizon at this time. And the only other opportunities that would ever be created would be, if down the road there were some, commercial or industrial building or something that, no longer served a purpose and somebody wanted to do something with it, you might have a request for that. But you basically are working with a fairly limited range of sites. So I'm confident that we can work something out that will work for Glen Ridge, but it's you have no choice as to whether or not to deal with the builder that filed the builder's remedy lawsuit. The question is only how bad is it going to be? And the how bad is it going to be relates to the fact that you have an obligation that, you're not going to be able to meet, but the closer you can get to meeting it, the better. So that puts pressure to increase the numbers. Obviously, there are concerns because of the neighborhood in which it's located, the uses around it, traffic issues, things of that nature that would cause it to be, lowered. And so that's what all the negotiation is about. But the worst case would be that you don't settle, you don't work out things with Fair Share Housing Center and with the builder. It goes to trial, and you end up with a development that is just as big, if not bigger, than what the developer has been proposing or talking about, and you don't have as much control over the design issues and some of the concessions that you might be able to get in mediation from a developer. So it's not great news for that particular site. It is, I'm sort of here to tell you that the best thing you can do probably is support the notion of some sort of a settlement and trust your counsel and the people representing them to work out the best deal possible so that you have some control. I'm a planner. I believe in municipal control of its destiny in terms of how things should look, how things should function, and I don't want to see you lose that. So I would be supportive of your trying to reach a settlement because I think it gives you maximum control. I mean, in a settlement context, for example, you can say to a developer, okay, but we would like mostly the market units at least. I mean, in the affordable units, there's a required mix of 1, 2, and 3 bedroom units. Not that many 3s, mostly 2s. But, the market units in the development could all be smaller units, like 1 bedroom units or 2 bedroom units. And so you would not have so many people living there, so many kids, so many cars. I mean, there could be a way to control that. You can't get that through zoning, but you can get it through a settlement agreement. So settlement agreements are good that way. Yes.
Betsy, can you address the issue for the potential of fee shifting? You said if we were to go to trial, then what could
Well, there's a possibility of fee shifting. I mean, I know that Fair Share Housing Center has been in their DJ actions has been looking for fees, and sometimes in very egregious situations, fee shifting is permitted so that the town pays the developer's costs in suing the town. Most judges are not inclined to do that, but it's out there as a possibility in a very egregious situation. Most judges come up through the ranks of being municipal attorneys themselves, and most of them have an understanding that there are limited resources. So it's less likely to occur there. With Fair Share Housing Center, which is a nonprofit organization, they may be asking for small fees in some cases. I don't know that it will apply in your case because it will be the developer that is instrumental in bringing you into compliance rather than Fair Share. So I'm sort of hoping that we can avoid that, but I don't know that for sure. But fee shifting is always a threat. It's always out there, and I don't want to see you have to do that. So I think that's one benefit of settling. I happen to think that even though Glen Ridge didn't go to COA, I don't think you'd be in any worse shape if you had gone to COA, or less. I don't think you're in worse shape now than if you had gone to COA, because I think that since this is the only real potential site, the question is just, how much can you do on it? And I'm not sure if you had gone to COA. First of all, you'd be out there with all the towns that were filing DJ actions, and this guy would be an intervener, and you'd be dealing with them in exactly the same way that you're dealing with him right now. So I think in your case, it probably saved you a little money that the council didn't, go through all the machinations of preparing plans that got thrown into the wastebasket. And believe me, for my towns that I prepared plans for, there were 2 or 3 iterations that ended up in a wastebasket because COA failed to adopt their rules, or adopt valid rules. They adopted rules, but that's not valid ones. So that's what, I'm here to, sort of advocate for consideration of settlement in a positive light, because I think it's how you can get the best deal. But I don't have a particular settlement to suggest tonight because one hasn't been arrived at. But I'm also here to give you some background as to how you ended up in this situation. And it's not really a situation where I think there's any pointing of fingers. I think it's one of those things that just sort of evolved and happened. I mean, if anything, I guess I blame the state, the legislature and the administrative branch for failing to do the jobs they were supposed to do under the Fair Housing Act.
Betsy, if you could.
Excuse me, would you let her finish her presentation and then
I'm
we'll
sorry.
have time
I'm
for
pretty much
questions?
done.
All right.
But I'm happy to answer questions, and that might be fine, Mayor.
Okay, let me say how we'll move forward from here. First, we'll let the council ask any questions that they have. Then we will move to anybody out there that would like to be heard. When you come forward to speak, please give us your name and address before you begin. Additionally, we would appreciate it if you would restrict your questions and/or comments this evening solely to the matters discussed in our recent open letter to the community and to the subject matter of Ms. McKenzie's presentation. The reason for this request is that we have as yet not arrived at an agreement with any of the interested parties, namely the builder, the special master, or Fair Share Housing Center. Therefore, we believe it would be not only inappropriate, but also, as we are in mediation, not helpful to respond to any questions at this time concerning any particulars pertaining to the builder's remedy lawsuit. We therefore will have to respectfully decline to respond to any such questions if asked. We have here with us tonight Jeff Janota, who is our expert on the vacant land adjustment, if anybody wants to ask questions about that particular area. We have John Maleska, who is our town attorney, who is pretty knowledgeable on this. He wrote the open letter. We have our town administrator, Mike Rohall, and I gather that Mrs. McKenzie will stay and answer your questions during this session. So if you want to specifically direct your questions, you may direct them to any of those individuals. And before we begin, would anybody like to sit down? There's seating
There are
in front
seats
here.
if you want to. There's 3 in the front here, and I could also give up. I'm taking up 2 seats with my stuff.
That's okay.
So, would you like?
Okay.
Would you like to see it? Okay.
All right. Are there any council members that would like to be asked
Yeah.
questions?
Yeah.
Go
I'm
ahead.
sorry, Betsy, can you speak to the potential of a moratorium on,
Once you, it's not really a moratorium, it's not called that, but it's kind of like that. Once you have gone through the process of either going through a trial and fighting and maybe not getting what you hoped to get, or settling and getting and agreeing on a number and moving forward with that and getting a judge to bless it, you would get a judgment, and you'd prepare a housing element and fair share plan that ticks off all the boxes and does everything you want. You would get a judgment of compliance and repose. A judgment of compliance and repose is a finding by the court that you comply with all your constitutional obligations with respect to affordable housing. You've done as much as you can, and you get repose from builders' remedy lawsuits for the period that's covered, that goes up through July 1st, 2025, which would have been 10 years back in 2015 when all this started, but it's a little less than that now. But there would be, nobody else could come along and sue you for a builder's remedy. Somebody could propose to do something, but you would be in the driver's seat. Does that answer your question?
yes, thank you.
You're welcome.
Anyone else?
gentlemen, we'll open it up to public. So if anybody would like to be heard, please come forward.
Yes.
I'm sorry.
Well, could you come up to the phone?
Do you want to use the mic? I can share.
I'm Cherry Provost, 57 Douglas Road, and I was hoping somebody from the Glen Ridge Historical Society might have come because they would be more up to date on the Glen Ridge Historic District Commission. And
The chair is right over there, Peter Harrigal.
Oh, okay. Well, maybe you should be the person speaking about this because I was chairman of the commission way back when, and I think that there is a provision that houses that are in this historic district, single-family houses, are not to be torn down. And I think 2 of the 4 houses fall under that part of it. So anyway, my concern is from that point of view. And so far, the commission has worked very well in Glen Ridge, keeping the town zoned and whatnot. And years ago, I was sort of involved in the Regional Plan Association, and my concern is also that there is a huge amount of overbuilding in our area. And I don't know who is overlooking all of that. And at what cost is it to our area as a whole? Period.
Thank you.
And I just, this isn't really a response, other than to say that the Historical Commission will obviously be involved in any review of what happens if there's a settlement. And it will go through normal site plan review, obviously, if there's a settlement. And it would also have to go through those reviews, even if there's a builder's remedy. But there are limitations on how far you can take it, in this context. But I appreciate what you're saying, and I think the historic issue is important.
But I think excuse me, Betsy, but it seems like the question asked was, can you tear down buildings or homes in a historic district to put up multi-family or higher density?
I have not examined your ordinance. My experience statewide on this is that there is a review. If you are going to tear down buildings, there's got to be a discussion with the Historic Preservation Commission about the value of the buildings that you're tearing down and what you're putting up instead. But I don't know how that works in Glen Ridge because I haven't examined your ordinance. Perhaps your own planner would be better at addressing that than I am. Or perhaps the chairman of the
One
Historic Preservation.
It's my understanding that the builder's remedy lawsuit supersedes that, but that it doesn't take away the historic commission from reviewing what's going to be done.
That's exactly right.
Yeah, I mean,
That's
if we
exactly
wanted
right.
to, we could zone it in a way, it's zoned right now, that would prohibit that from being built.
And
But
you
that's
saw how
not a
far that
defense.
got you, right?
But that's not a defense,
Right,
is that correct?
exactly. That's correct. It is not a defense. But it still would be subject to review. And if there are things that are important, there are sometimes ways of working those into the project. I know that I was working on something in Hoboken where there was a building that my client did not think was historically important, but the town was concerned about it. And so, they agreed to use some of the materials from the building and also to have a little sort of museum about that building, which served largely military functions, and so that they work that into the design of the building. So sometimes there are ways you can address the historic importance of something, even if you have to tear down a building.
Yeah,
But I'm not advocating anything other than saying, yes, the constitutional obligation to provide affordable housing supersedes local considerations about zoning.
Yeah, but Betsy, to put it another way, if we said our Glen Ridge Historic Commission says that historically there's never been a high-rise building on that site, therefore one should not be built.
That's not an argument.
That's not an argument we can make.
I can't. That would not fly.
Right.
Yeah, Mayor, I mean, there are a lot of competing interests with, historic preservation, that site in particular, the buildings on that site. And I think the distinction is there's a difference between something being in a historic district
Yes.
and the building itself being designated in its own capacity
Correct.
as a historical site. There are buildings in town that are in the historic district, but there have been alterations. There have been some cases where they've been replaced. And what we're dealing with here is our local ordinance, but the builder's remedy is predicated on a state constitutional argument.
Exactly.
And municipalities are, by definition, creatures of the state. We operate at the pleasure of the state, and the powers that we exercise are those that are given to us by the state. And to the extent there's a state constitutional issue, it's really an issue that's greater in authority than our local issue. And, we have, when I say we, the mayor and council, the administrator or expert, we have been involved with this proceeding since it started in July of 2015.
Right.
We have been in this for a year and a half. And we have been hoping that with the Supreme Court litigation, we have been hoping, which still is in play,
Yes, it is.
we've been hoping with a lot of these other issues that, not that we're ostriches and that we put our head in the sand, but I think we were of the opinion that the longer we could delay a final decision on this, there were other factors in play that may have been determined that would also affect us in a favorable way. But, as the special master has indicated, even with the use of experts, and even with our intra-local agreements, I think the one comment that Ms. McKenzie has made is that whether you go with the numbers that are put forth by our experts, or whether you have to live with the numbers that are put forth by the public advocate for affordable housing, there will be a number that everyone knows we cannot meet. It's just our fair share. Whether we can comply with our fair share, whether we can do our fair share, is a different question. But there will be a number that is allocated to us. And from 1990, when Mr. Roll did the first certification and got the first certification, up to this very, very day, we had no land. So it made no difference to us what our fair share number was. We always had a fair share number. This is not new. We always had a fair share number. It's just that because we got a credit against it, we got a credit because we couldn't do anything. But, everything changed with the Supreme Court in March of 2015. March of 2015, the New Jersey Supreme Court said, you know what? We're throwing this onto the courts. We're opening this up to the builders. Within 2 months, those 5 lots were under contract. And the lawsuit was started in July of 2015. And we fought that, and we fought that, and we've been fighting that. And that is what has brought us to this point. It's a circumstance over which I think we can say we really had no control. We did not, that land has always been there, but it was never before available for something like this. Now someone has bought it, owns all 5 lots, it's 2.3 acres, and that person is doing what he can do under the law. I mean, the law has given him what's called the builder's remedy. And that person is exercising his right. We're defending him. We're defending against it, but as the special master has indicated, zoning means nothing. Because this is an opportunity for us to comply in a small way, not in a total way, to comply in some way with what our fair share housing obligation is, with the idea that even when we do this, there's also going to be a big number out there that we haven't met, but we will be in a period of repose, meaning that if we can resolve this, hopefully 10 years from now, maybe this issue will still be here. It's been here since 1970, right?
It will probably never go away. It will probably never really go away, but you'll have a hiatus. You'll have a
we never thought we would see this here in Glen. Essex Fells had it. The projects that are up where the Essex County Penitentiary used to be, there's about 5 or 6 houses there. That was Essex Fells fair
Builder's
share.
remedy. It was a builder's remedy.
Builder's
right.
remedy was. Anyway, I'm sorry, but I just thought.
That's all right. No, I mean, and the truth of the matter is that, you know, the question is the validity of your zoning, and your zoning is only valid if it provides for your fair share of low and moderate income housing, which the only way that you can get a determination of that is either from the Council on Affordable Housing, if there were such an animal anymore, or from the court.
Okay, anybody else? Peter, did you want? Sure.
Seems to be the man of the hour.
Well, I'm not sure about that. Hi, I'm Peter Harrell at 42 Glen Ridge Parkway. And I am the chair of the Historic Preservation Commission, but I'm not here in that capacity. I can, you know, we have, the commission hasn't been asked to participate yet or pass on any sort of thing in connection with this. And so we haven't been involved at all.
Mm-hmm.
And I don't know, as I sit here, in response to the last question, I know in the past, if houses have been demolished and new houses have been put up, we've done an analysis of the houses that are being taken down and whether they're contributing or non-contributing houses. And I don't know, the commission certainly hasn't made an assessment of the properties that are there, so I don't know the answers to those questions. And in sort of in response to what John said, I don't know if in this instance that really matters. So we haven't made any determination of that at all. All that being said, I do have a question. You spoke of the worst case scenario.
Yes.
What's the best case scenario?
The best case scenario is to reach some sort of an agreement with the developer to develop the site in a way that you can all live with.
But the best case scenario, if you go to trial and we win, it's not going to be they can't build it and it's zero.
Right.
It's going to be a smaller number rather than a bigger number.
Yes, but that would presume that all of that there was some expert that the court would accept that would actually have your number within a range that, you know, you could actually produce.
Right. So it seems like best case scenario, there's still going to be a development there. And in terms of worst case scenario, in terms of the numbers, I know you didn't want to talk about specific numbers, but I think in Mayor's letter, there's indication that the developer proposed 125 units in total, and 19, I think, would be the affordable.
Yes.
The affordable
That was the
house.
initial proposal as part of their building zoning law.
And has
So
that proposal changed? Is worst case scenario the 125 units to be built, or?
Well, you know, he might get mad at the whole process and up that if it goes to trial. So whoever knows, if he could amend his complaint and ask for 140.
It could be worse.
It could be worse.
You know,
Yes.
Peter, too, the other thing that should be said on this is, and in the letter, you know, we had said that when the Supreme Court decision came out, we sort of figured this had nothing to do with us. I think we used the phrase it was a passing interest to us, as the Mount Laurel litigation has been for all of these many, many, many years. But, you know, in this particular case, it just turned out to be different because, you know, these properties became acquired.
Right.
And it just made a big difference with this.
So it seems like the best case scenario is we reach an agreement with them and we get some control and management over what goes on.
Absolutely. Yes, because you still get to do planning.
Right.
Which is, you know, in my opinion, as a planner, that's valuable thing. And of course it would go through site plan approval with the planning board, and of course it would have the review from your commission, and that would be part of your process. And so, and you would have that kind of control as well.
Yeah, and Peter, the second part to that is, you know, as I was starting to say, when this decision came out, it was of no moment to us. But what happened here, when this lawsuit was first brought, this lawsuit was brought not so much as a builder's remedy, but this lawsuit was brought because the developer wanted his plan, which at that time was, I think maybe, it's a matter of public record. I think the builder wanted to put in 80 luxury units. And
Previously, right.
Previously.
Before he filed the lawsuit.
before he filed the lawsuit. And the plan was that there were luxury apartments that were going to go there, and the developer wanted us to refer that over to the planning board, to have the planning board consider this area as an area in need of redevelopment. And when we looked at this, you know, the decision was made collectively under the statute that these were not properties that were in disrepair. These were not properties that were blighted. These were properties in which homeowners were actually living in and maintaining the properties. And we had made the determination that it was inappropriate to refer it over to the planning board because it didn't meet the initial test.
To be an area that needs redevelopment.
Correct.
Right.
And then when the lawsuit was brought in June or July, the lawsuit was not seeking the builder's remedy. The lawsuit was seeking to have that area determined to be needed development so a luxury area could go in.
Well, once he filed a complaint, though, he had the builder's remedy in the
Correct.
125.
Correct, because at that point, you know, the sky opened for the builders. And this is the point that we were making before. Once that Supreme Court decision came down and the builders started analyzing this, you know, this became the vehicle to turn this into a much different lawsuit. So, you know, we were somewhat blindsided by this, I would say July of 2015. This was certainly not our expectation.
Correct. There is one thing I would point out. The planning board back in 2003, I think, had looked at these properties as potential area for multifamily. So that it's probably not unreasonable for him to have thought of asking for that, you know, consideration. But, you know, it might have been difficult to declare it an area in need of redevelopment, which requires pretty much, you follow the court decisions, the determination of blight, and I don't know that it rose to that level, but I wasn't part of that process. So.
Yeah, Betsy, Peter's question raises a good point, though. When you try a case, you're in a piece of litigation. Usually there's a clear winner and a clear loser. These are unique circumstances here. And those unique circumstances make it that there's going to be a winner, and it's going to be the other side.
Well,
it's a matter of what we can do to fashion this that best serves our community.
I think that's exactly right. I mean, the filing of the builder's remedy lawsuit for a town that has not, you know, technically been in compliance means that he gets a builder's remedy. The question is not whether he gets one, it's what he gets. And that's where the judges appoint masters to help towns and developers work together to, you know, to try to figure out, you know, what maximizes the number of affordable units you can generate from the site while still recognizing reasonable planning considerations on the part of the town. That's sort of theoretically my job. And hopefully I will be able to get there one day with you.
Betsy, to what degree can we constrain and shape the whole process with planning considerations and planning principles, and how does that differ under a settlement versus litigation scenario?
Well, in a settlement, you know, you can say to a developer, well, you know, you could have this many units, but we want this, and this, so that it will work for us. Whereas in a builder's remedy lawsuit, if the judge says you can have this many units, and he bases it on a plan that the developer has submitted, that's basically the plan that becomes the builder's remedy plan. And, you know, you get to go through site plan approval, but, you know, you pretty much have to approve it. So your only way to exercise control over, you know, bedroom mix and amenities and open space and, you know, parking issues. I mean, they, you know, theoretically would have to meet their parking requirements in any case, but how they meet the parking requirements, all of those kinds of things, those are really things that that you can get the way you want them or closer to the way you want them. Maybe not, you know, your dream of how you'd have it, but closer to the way you want them. If you settle, you can't get them if a judge orders it, because you just have to implement zoning, and the zoning can't restrict bedroom sizes, and it can't, you know, you can have a reasonable open space requirement, but you can't have restrictions that would prevent the development from occurring the way it's been approved. So, you know, as I said, I'm an advocate for planning. I would rather see you get involved in the planning process and work something out and see what you can do. I mean, you know, the developer is, I think, interested in talking with you and has been interested in sitting down. Just because there hasn't been a resolution, I think, doesn't necessarily mean anything. But, you know, I would urge you all to consider what's most important to you in the development of this site, what kinds of things you want to accomplish, and use those to shape maybe what comes out of the site. And it's not going to be, you know, it's probably not going to be as few units as you might be comfortable with. It'll probably be more. But it might, you know, you might be able to live with how it looks and how it functions and, you know, the parking and the, you know, open space look and the design of the buildings. You might be able to live with all of that if you work with the developer. So that's kind of what I'm hoping will happen. But of course, I don't make the decision. I just I lead you all to the well, but you have to decide to drink. So.
All right, you're next.
Hi, Tim King, Soda Park. I have a question about if we were to create affordable housing options through a different remedy, does that limit a potential award? I'm thinking specifically of perhaps opening up zoning on carriage houses.
Well, you mean accessory apartments is what we call them, and they become accessory affordable apartments. Had you already done that, you would be less vulnerable to what the builder says. But since you didn't already do that, the builder's remedy takes precedence, and anything else you can do gets added to your plan. But it doesn't give you leverage with the builder's remedy. Now, I suppose that, you know, if you already had a plan and you were before the courts and you had to modify the plan, you know, if you had, that would be the one thing that would be different if you were in a DJ action. You might be able to think of other alternatives and maybe use the intervener site less. But I would say still, you don't have that many opportunities in Glen Ridge. It's a small community. I mean, it's a lovely community, by the way. I mean, I didn't realize how skinny it was until I started looking at your maps. But I'd always pass through it on my way, you know, from Springfield up to Montclair, and you know, I always thought that's really kind of nice there. So I do like Glen Ridge.
My question was,
Could you give your name and address, please?
Myers,
Under the mic.
Sure. When you were outlining the things that we might be able to talk to the builder about as concessions, one of the things I noticed you didn't say is number of units. Was that intentional?
No, you can talk about the number of units, absolutely. In the end, it probably won't be as low as you'd like it to be, but it might very well not be 125, and it certainly wouldn't be worth that if you reach it.
Yeah. I can speak for myself and everybody that I've talked to about this issue, obviously, or I shouldn't say obviously. Everyone I've spoken to has no issue with our fair share of affordable housing. It's the context in which it's being built. It's not the 19 units that is under discussion.
It's everything that's coming with it.
106 other units.
Yes, yeah.
So,
I understand.
to me, I guess I wonder, I thought the letter that you wrote was really great. I'm just wondering, in terms of expert legal advice, that is someone who's representing the town. I understand you're sort of mediating this.
Right, I work for the court, basically.
Representing the
Yeah.
town in a legal capacity that's an expert in this area. Who would we engage? I know we had a consultant do the calculation of the numbers, but it would seem to me like having a legal expert that would evaluate our legal options and strategies to pursue, whether that's the idea around the carriage houses thing, where I understand that towns can sort of sell some of their obligation off to
No
other
longer.
communities, you know?
That's been invalidated. Unfortunately, because I actually like that kind of mechanism, but
Yeah.
that's gone
It
away.
just seems to me, I guess, as we're looking at this, it would be good to have, someone who really understands all of the specifics of this, giving us all of our options rather than just sort of looking at the settlement on the table as our only option. Because to me, that just allows us to engage in the settlement in a productive way to know sort of what our bargaining position is, rather than just being told that, you know, we've got to settle with this developer and that's really the best option when we haven't heard any other options.
Well, let me just say that the reason you haven't heard other options is because it is too late for you to propose alternatives and have the court accept them over the builder's remedy. If you want to propose them in addition, you may be able to, but.
I just don't know that anybody that's representing Glen Ridge only is telling us that, maybe they are.
Well, no.
We retain
They're not
counsel.
they're not telling you the things that they know can't happen.
Excuse me,
Yeah, why don't we,
The answer to that is that we have not been alone in this. We initially joined the various consortiums. There's a statewide consortium with a group of attorneys who are helping to oversee all of the individual litigation. And we are part of that, we pay our dues into that, there are meetings with that, so there's an overall coordination. You know, we also have learned that in the different counties of the state, some judges are handling these matters differently than other judges in other counties. We are also, by virtue of the fact that we are in this consolidated proceeding with, I'll call them the West Essex towns, or what are considered the suburban Essex towns, we're also involved with that. And the purpose of us going into this consolidated hearing for Essex County is to make sure that whatever our fair share number is, and that's the key to this, that we are not going to be treated any differently, or the methodology that's going to be employed in coming up with what our fair share number is going to be any different than the other town in Essex County. And that's the reason why we're part of that consolidated hearing. But the more important thing is that I think that it hasn't been litigated to its final conclusion, but I think what the special master is trying to tell us, either subliminally or sometimes the handwriting is on the wall, what I think she's telling us is that, we can hire all of the experts that we want, we can be involved with all of these consolidated proceedings that we want, and we can pay whoever we want. The bottom line that's going to come down here is, what is your fair share number? And have you complied with it, and can you comply with it? And the only question that's here is, we have our vacant land expert here too, can address that. The question that it comes down to is, we all know that we have a number that we can't meet, and we all know that we don't have any vacant land, and there's nothing that we can do to satisfy this. But we do know there's an unmet need, and the question is, there's now a site available, and the question is, how much of this unmet need are you going to put on that site? And that's the planning issue. So it's not so much looking for some expert guidance. I think it's the issue is very narrow at this point. It's just really what is your fair share number? Have you met it? And if you haven't, how much is going to go on that site, which becomes the planning issue that the special master deals with.
yeah, but to be very succinct about it, we have had legal counsel, expert legal counsel guide us, and we also have had expert consultants guide us on the fair housing obligations. So it's not like we're taking direction from the other side. We're defending this litigation and actively defending it with experts in the particular areas that we require. We've now gotten to this point where we're many months down the line, much further into the proceedings, and something will have to occur one way or the other.
Sorry, one other just quick related question.
Go to the mic, please.
Sure. So, in the event that there's a settlement and we satisfy whatever percentage of our fair share is determined, and we get our, I know it's not a moratorium, whatever it was called, until 2025 and 2026, what is preventing the same thing from happening again? That's not that far from now.
What may happen by then, because we'll have a different administration in Trenton, is there may be a council on affordable housing again doing its job. And then you would have the option of submitting whatever you've done to the new council on affordable housing and, asking for a blessing for your plan, and you would not have to go through the litigation process again. So you would have that. There you are. I was looking for you. You sat down on me. Okay.
You're next.
Good evening, Lindsay Don Mann of 12 Cambridge Road. I had 3 questions, and the first is about timing. I know a settlement has not been reached, but if you cannot share any concrete dates at this time, when can we expect the next status? The second question I have is whether, and it seems that way based on the open letter and tonight's special master presentation, the range of vacant land adjustment is part of the settlement discussion, and whether that range of where from 19 we can go, give or take, in a range fashion can be shared this evening. And finally, Mayor Patrick, in respecting your wishes and not speaking off topic on anything that wasn't raised this evening, what is the best way for residents to voice concerns and help, if a settlement is reached or in settlement talks, to share their viewpoints and direct, where this project may be heading?
Can I answer the middle question
Yes,
first?
the last one.
And then you can get the last question answered if you want by them. But in terms of your middle question as to whether, if there were a settlement, you would end up settling all issues associated with the case. So it would not just be letting the builder have what he wants.
And the 19.
It would be, it probably is gonna come down to that. I mean, that's my thinking. But based upon what I know, and I have seen nothing in the very excellent vacant land analysis that was done by your planner to suggest that there are any other opportunities. So I think that's what you're looking at. So I think that, that probably would be, your plan would be built on that. Plus, there would be a rehabilitation obligation, and apparently there's a medical office building where you might get some, a payment, from out of the development fee ordinance, where you could collect some money from them and use that to rehab units if people needed it, the rehab obligation is existing units in Glen Ridge that are occupied, that are dilapidated or deteriorated, that are occupied by qualified low and moderate income households. So that's, you can have a program for that. And hopefully you'll have some funding for that out of that development fee.
Betsy,
Yes.
maybe I can just give the audience kind of a quick summary of what a vacant land analysis is.
That's a really good idea.
We've heard it mentioned a number of times tonight. Essentially what we did is look at all the parcels in Glen Ridge, and you're allowed to eliminate parcels that are environmentally encumbered by floodplains, wetlands, steep slopes. Then you're allowed to eliminate parcels that are parks or open space or deeded on your recreation open space inventory. Municipally owned properties like the DPW or the municipal building. And then we look at properties that can meet a density of 1/6 on a lot. So we get down to the point of, doing a holistic analysis of it, and then getting to the point of even going out in the field and looking at aerials to see if we can put two parcels together. If we see a vacant parcel next to another adjacent parcel, can that support that one, that 20% density for that site? So throughout the process, our vacant land adjustment or analysis has shown that there's no property. As everybody probably knows who lives here and drives around. There's not, we did find small vacant parcels, but we weren't able to put them together with any adjacent parcels that have any developable property. So we go in with eventually submitting our housing element and our fair share plan, showing that there's no developable land. And the only way it's going to be developed in the future is if parcels are put together and redeveloped.
I think also, isn't it true that it isn't just an issue of putting a development on a small parcel? If it's for affordable housing, either 15 or 20% of those units have got to go to affordable housing. So you can't just build one. If it's 15%, you've got to build 6.
Exactly.
So you've got to look at it in that way. So that presupposes a fairly substantial size of property to accommodate 6 or more units.
Correct.
So I think that's part of the issue, is it not?
That is part of the issue. That's the majority of the issue.
Yes, it's an issue, absolutely.
I wasn't
You
quite sure
nailed
I heard
it,
that.
Mayor. Go ahead. And you had a question about,
Timing and then input.
Michael, do you want to answer the question about input, hearings?
So if you email me, Michael Rojo, emails on our homepage. I'll share any correspondence with council. We also read it as part of the public presentation at each council meeting. So if you have any input regarding the process or what you think should happen at the site, if you email email me, I'll share it with our attorney and the town council.
I think what she was asking about is when we get to a point of making a decision, we will have hearings.
We'll definitely have, the decision will be made in public, at public hearings, there'll have to be a resolution by the council. So we'll notify, we'll send out email blasts ahead of time, we'll put it on our webpage when that time comes. So it's not something that's going to be put on the agenda that evening. We'll have at least 2 weeks advance warning and advance of the agenda item, and the fact that there is the decision-making process is being made in public.
So whenever the next update is available, you can't say, but we'll have 2 weeks.
At least 2 weeks. If it's not, I'm assuming, because we try to prepare an agenda about 2 weeks ahead of time. So if there is a settlement, I would not want to put it out the Friday before, but give plenty of advance notice. Just send the mayor out a letter regarding this meeting. What we'll do is say we're notified through email and also on our website and also on Channel 36 or 38, depending on the.
And to whatever answer I can give you, your first question is pretty fuzzy, but I can only say that we are committed to working through this problem and getting it resolved as expeditiously and also as well as we can do for the community. So we are not sitting back. We are moving it forward, and so hopefully it will be sooner than later. But having said that, anything can happen.
Yeah, Mayor, I might add one thing to that. I've attended the case management conferences in Essex County, and the last one I was at was just about a week ago. And what the Essex County judge supervising the Essex County consolidated proceedings, has indicated that the time for these delays in reaching a decision is coming to a close, and starting in April, the judge has indicated that he is going to start conducting trials. He has not told any one town who that first town will be. So it could be anybody. It could be us, or it could be Caldwell. It could be anybody. We don't know. But as the special master has indicated, I think that we would be better off, if we could, to resolve it on our own terms rather than forced into a protracted proceeding where we don't know what the results will be. As I say, as we have discussed here, is that to date, we have not yet constructed one affordable housing unit. We have areas designated for that, but we have not yet constructed a one. Our position in litigation is not going to be necessarily a good one.
Right. Thanks for sharing what the judge has imparted.
Yeah, so we're trying to be ahead of it may not be us who's first, and it may be.
I'm going to try to.
It may be an idle threat. It may be an idle threat in the sense that, I'll give you a couple of extra months. We don't know. We don't know where that wheel of fortune is going to end up. So, we're just trying to be proactive on this rather than reactive on this.
Thank you. Please.
Kelly Huddleston, 30 Lorraine Street. You answered my first question, which is there a date set for the hearing, which is no. My second question is, obviously, from what I'm hearing, maybe I shouldn't say obviously, from what I understand, it sounds like we're going to have to end up with a development on this property regardless. Is there a way, and maybe this is outside of what you wanted to discuss, Mayor, but is there a way for us to prioritize our what we want accomplished on that piece of land? I think most of the concerns that I've heard from my neighbors are the schools already have enough students. How are we going to add enough room? We're already looking at a lot of money for the central school. What are we going to do to have enough room for that many more children if every unit in there ends up being family with 2 or 3 children? There are things that are available to us under the law and under the remedies that could say, make this over 55 housing that no children are allowed. Because there is affordable housing for seniors that is required under the law.
It's a very good question, but let me just tell you what the answer is. Because it's your only opportunity, you can't restrict the only opportunity you have for low and moderate income housing to 55 and older to age-restricted housing, because you can only have 25% of whatever is called your, okay, I'm going to throw out a term, RDP, which means realistic development potential, which is how many affordable units you're going to actually be able to generate in your plan. Only 25% of those can be age-restricted, and the idea was to allow families the opportunity to move to places where there are better schools. But it applies to the affordable units, not necessarily the market units. So one thing you can do is negotiate with the developer on the sizes of the market units, at least, those extra 106 units out of the 125-unit proposal, you know, and try to get more of those maybe to be one-bedroom units where you will be likely to have, you know, millennials but not people with kids, that kind of thing. That's something you can negotiate in the context of mediation. You can't zone for it, so you wouldn't get it as a builder's remedy that the court awards, but you could get it in the context of a settlement, those kinds of things. And believe me, all of those issues have been on the table and discussed as part of the mediation sessions we've had so far. Hasn't resulted in anything being resolved, but those issues have been heard because all of your representatives, I think, are acutely aware of the issues of schools and traffic and neighborhood character and open space, and, you know, there's a lot of those issues that I've been hearing. So your point is well taken. There are things you can do, but the 55 and over, you know, maybe by the time you get to the development of the country club, if that ever happens, you could make part of that age restricted and still be within their 25% of what you do. But I don't think you can't do all of that, and you can't do all of this.
I'm sorry, is it possible to do all of the non-affordable housing?
You can't do that in one building, and right now there are federal laws about that it has to be a separate project. If you're having age-restricted units versus non-age-restricted units, they have to be in separate buildings, actually. I've gone through this in a couple of other towns where, you know, that was tried, and it's because of the federal laws about age restrictions, because otherwise it would be unconstitutional to age restrict housing so that you leave out school children, but the federal government, recognizing that there is a need for senior citizens housing, said you can do it, but you have to make that whole building designed for seniors and to meet the needs of seniors. You can't just do it so you're eliminating families. So that's sort of what we're up against.
Yeah, Betsy, can you just expand on that defense, the defense of that? This is an unfair impact on our school system. That you cannot proceed with this development because there's a potential you will adversely affect our school system.
It's not an argument that would ever fly with the courts, because the court's position and the constitutional position in New Jersey is that municipalities are responsible for educating the children that have to live there, and if you have a constitutional obligation to provide low and moderate income housing, you're responsible for educating the people that live in the developments that produce that. However, that doesn't mean you can't figure out ways to limit the number of school children, at least in the market units. There are one of the nice things about affordable units that even though they will likely have children, in the affordable units are fairly carefully regulated. It's not like just having housing that's market-priced housing that people come in with Section 8 vouchers and they can, you know, as many of them as can get in there. You know, the administrative agent that places people in these units is going to place in a family that fits in that size unit. Now, they're rental units. If that family gets too big, they may figure out when another one becomes available that's bigger, they can move them out into a bigger unit so they fit the unit size. And there are guidelines about how many kids, and, you know, that parents not in the same bedroom with the children. Boys and girls can have separate bedrooms. If you have, obviously, two siblings of the same sex, they would share a bedroom. Adults living together, like if your mother is living in the household and, you know, the mother and daughter are sharing the household and living with the kids, the mother and daughter each get separate rooms. So you can see how that works to limit the number of children, because the idea is to provide decent, safe, affordable housing, not to have overcrowding, because overcrowding is one of the things that sort of leads to it's one of the categories of housing units that are in need of rehabilitation, is units that are overcrowded. So there are some benefits to doing it this way as opposed to sort of, having it sort of happen on an ad hoc basis.
So, pardon me, also Betsy, in your experience, what percentage of the ratio of unit to children?
Well,
do
in
you see?
terms of market units or developments that, are just apartments, similar to what I guess would be proposed here, one kid for every 11 units, one kid for every 10 units, mainly because you're often dealing with small units, they're upper stories. I mean, people with children who are older in school age need access to a backyard. And so people will maybe come into these units and they might have a child there, and they might even stay until the child reaches school age, but at some point they have to get a yard. I mean, my own daughter and son-in-law who live in the D.C. area had, they ended up, I think, with 3 kids in a 2-bedroom condo, but my grandson said, "Grandma, I wish I could live with you. I want a backyard." So, and they finally bought a house, and it's a plenty big house, it's 5 bedrooms, and they can fit all their kids, and that's fine. But they just, they were in there longer. But it was a condo, it wasn't an affordable unit. Nobody could regulate it, and nobody was telling them what, where they had to live. So they stayed stuffed in there until they could find a place they could afford. So.
Next.
Hi, I'm Molly. I live on Glen Avenue. I have a question about the vacant land adjuster. So is that something that went back to the first go-around? Is that like a defense that we could have used in rounds 2 and 3?
I can answer that maybe better. You actually, COA would have honored, had you gone in, they would have honored the vacant land adjustment. Whether they would have reopened the question of the golf course zoning as to whether that really created a realistic opportunity or not, they might have seen if you could do some other things like accessory apartments or some of the other ideas that this gentleman suggested. They might have asked you to look at some of those other alternatives as well. They might have allowed you to leave the zoning in place, but they would have looked for other alternatives. But they would have probably honored the vacant land adjustment. In the third round, towns were redoing their vacant land adjustments because things have changed in New Jersey in terms of what we consider to be developable land. And if a developer has assembled a parcel and proposed it for development, it becomes developable land.
And it wouldn't have affected the builder's remedy. You still,
No, it would not have affected the builder's remedy. You're right.
So having that vacant land, whether it's in the prior round or in the proposed third round, would not have affected development.
Last year, we would have been, we wouldn't have built into building at all.
No. You would have had to have complied well before that, and you wouldn't have necessarily complied. I mean, there really is no guarantee that if you've gone before COA that one of these property owners wouldn't still have surface and come forward with a proposal. I mean, I think they've been thinking about developing their property for a while.
Yeah, but we've never complied. We haven't made any affordable housing.
Correct.
Because we haven't had an opportunity to. So the fact that whatever we did before here wouldn't change where we are now, where we have a claim that there's a place where we could build affordable housing. We have an opportunity to satisfy some of our obligation. That's the claim. No matter what we did in the past, it didn't satisfy that obligation, and
Correct.
it wouldn't change where we are now.
That's exactly right. Even though you got a vacant land adjustment, and you're still going to get a vacant land adjustment, nothing was built as a result of that. So that's, I think, the main point. I agree with that.
So has there been thought to kind of be proactive for, I think like the gentleman was saying, in 2025, when this may happen again, maybe asking the developer for more affordable units, for this particular development, or maybe upzoning certain areas of the town to prepare for, 10 years, what's going to happen?
I think in the next, well, I guess it's really 8 years now, assuming that we were to settle and get the court's blessing and have some repose, I would urge you to look for other types of opportunities that you might be able to create on your own, so that if there is a state agency established that you can go to, that you could go to that state agency and get blessings for your plan. I would urge you to do that. I mean, you don't have to think about it all right now, but the 8 years of repose is a planning period. where you can start to think about opportunities. And there may be opportunities that surface that right now you couldn't have imagined, you know.
And what about as a strategy to ask the developer for more affordable unit services?
It might make some difference. You could ask for more, but if you ask for a higher percentage than you're normally, you know, allowed to ask for, you know, the problem is that if you do that, he'll probably want more units. So that's
Right.
the trade-off.
Yeah, you gotta be careful what you ask for in that regard.
You might get it, right.
Right, because
Yeah, but
it's a
you're-
numbers game,
no.
it's a numbers game, they back into it, so
You're
what
well
happens is,
taken. And, you know, certainly it's something, you know, to look at and talk about in the context of mediation as to whether they could do more than, it's usually 15% if it's rental units because you get a rental bonus that you can add into meeting your obligation, or whether it's 20% set aside if it's for sale units. But, you know, it's certainly worth asking for, you know, to do, if they would do a little more. That's not a bad strategy. I don't know, if it comes with a cost, though, that's more units, you might, you know, it's a balancing game.
The whole point of the developer, though, is to try to make money. That's why they're trying to do it. So
Yeah,
that
that's
it's
true.
uneconomical for them to have more.
Well, no, I agree with you. I think the idea is, that's the whole point of trying to figure out a way to make it work for you. I agree with you 100% on that.
Hi, I'm Yolanda Bell of 238 Baldwin, so this is my street.
Oh, okay. I like the street.
So my one question is, this whole discussion is about the affordable housing
Yes,
part of it, which is about 19 units.
out of the 125.
So
yeah.
if we took that out, are there ordinances, laws that will protect the community, the residents, the resources of the community?
What
Would
do you
we
mean
be having this discussion if it wasn't about the affordable housing part of it?
No, you probably wouldn't, because he's only allowed to sue if he's proposing a substantial amount of affordable housing.
Okay.
That's the vehicle under
And
which
so-
he could try to
So
compel.
we're meeting that obligation, essentially, right? This will happen. We'll
Yes.
meet that obligation.
Yes.
So is there anything else we can do to protect the other 120 units that he wants to build? Is there a way to restrict that?
I'm not sure I understand your question. He'll build the affordables, but he won't build the affordables without building the other units.
But is there anything in our zoning and ordinance that will restrict how much he can build?
Your zoning, okay, now I think I understand your question. Your zoning is basically put aside by the court, at least with respect to that site, while the builder's remedy is worked out. So what you have in your zoning has no relevance to what will happen on that site. It's all about the affordable housing obligation. So you can't control
So
it.
I understand it supersedes, but so we'll supersede for the entire site.
Yes,
Uh,
yeah.
There's nothing we can do that will help.
I'm sorry, and you know, the reason the court, the Mount Laurel 2 court set up the builder's remedy like that is they knew that developers were interested in making money. And they knew that if they harnessed that, which was intentional, that if a developer thought that if he was, as long as he was providing affordable housing, if they thought he could make a lot of money, that would be a way that affordable housing would get built.
If we were proactive and had our home developer come in and build 30 affordable housing units, and so therefore we're kind of superseding our requirement, our fair share.
Had you done that
Yes.
previously, but that would have meant acquiring this property from the owners, because I don't know where else you would have done it. And that's, you know, I mean, if the owner didn't want to sell it to you, you'd be in a condemnation situation, which towns normally don't like to do. They don't like to condemn private property. It's just, so, I mean, you know, there's a lot of what if, you know, what if we had 50 affordable housing
So for
units?
developer, we couldn't come with another developer and say, well,
No.
maybe this developer will put 30,
Yeah.
and that's all we're gonna put, is maybe 40.
Not unless you swing a deal to buy it from this guy, and he's gonna want everything he could have made out of it, so, yeah, no.
If there were-
Unfortunately, it's probably not as smart.
If there were
You
vacant,
raised a good you had.
Wait a minute,
Oh, I'm sorry.
if there were parcels that were open or municipally owned parcels, the municipality could work with the developer
Yes,
to build on that site.
on the municipal
But in
property.
this case, it wasn't vacant, the developer put the parcels together.
Right.
You know, there's always gonna be, when we talked about the vacant land analysis, there's the realistic development potential of what can actually be built out there. And then behind that is what's called the unmet need. It's what you can't build, but you're still ultimately responsible for it.
Correct.
And where that comes into play is a situation where if a builder comes in and does have a vacant parcel or a commercial parcel that is vacant, and he has the opportunity to develop affordable housing. So this one site is not going to meet the entire obligation, but it's addressing the obligation on that site in an appropriate, density and site layout that we've been kind of discussing from a, 10,000-foot viewpoint tonight.
Exactly. And it will get you that with your, keeping the zoning on the golf course site for, addressing unmet need and maybe some other provisions that would allow you to capture opportunities as they came along, you would get a judgment of compliance and repose with the vacant land adjustment that reflects what is being built.
Right. And we've identified existing group homes, or one existing group home
Yes.
that we're carrying forward 3 credits to address.
Which is something, that's good. If anybody knows of any other group homes, tell Jeff.
Paul, you had a question?
No, I was just going to make a statement. She raised a very good question about what our share number is. I think Betsy indicated we can't comply with it even at the low end now, but there's
Right.
there's a fair share housing advocates that say our future need is over 400. So that's a debate. Those are issues that are, open.
And I will say this, that if you should settle, and part of that settlement is with Fair Share Housing Center, they have a provision in their settlement agreements, which, first of all, if you settle with them, you get a discount off their number, but also they have a provision that if a future adjudication that sticks, either from a judge or an amendment to the Fair Housing Act or new rules from the Council on Affordable Housing, would reduce your number by more than 20% of the number you settled on, you could go back into court and get your number, your unmet need reduced. It doesn't change your realistic development potential or which is, what you can do. But it does reduce what's out there hanging over your head, and that's a good thing. So, and it doesn't work the other way. If the numbers go up, they don't get the benefit of it. They will honor the settlement. So that's not they put that in all their settlement agreements, and because towns didn't want the risk of settling early and then finding out the numbers were lower, so they sort of had to do that. And a lot of towns have settled with them, and they're hoping that provision kicks in someday.
You want to come next? You've already asked the question. We'll take the... Okay, go ahead. Whatever. If you've raised it, go ahead.
The suitability of the lot, whether or not the lot would be suitable for 120 units or
125.
How likely is the judge to weigh in and find that the lot is suitable in this location for...
That's a very good question. There are specific criteria that are set forth for determining the suitability of a lot to accommodate inclusionary development. It includes things like access. If it's got access to a street, it's got access. The availability of sewer and water. The lack of lack of environmental constraints that would impede the development. When I say environmental constraints, I mean things like wetlands and floodplains and steep slopes that would make, the development not safe. The fact if the property is not, listed on an open space list with the green acres, the ROSI. If the property is not preserved farmland, if there's all these criteria. This property there's nothing in those criteria that would make this property unsuitable.
So would the judge consider the context that the development would go into?
The judge is likely to look at the context. In the end, the judge will probably ask for my recommendation. He will make his own decision, but he will ask for my recommendation as to what I think is what should be supported on the site based on considering A, the context and the site itself, and B, the extend us a municipal obligation that's unmet.
I will ask you about that,
I haven't made that. I'm hoping not to have to do that. I'm hoping to be able to stand up in front of the judge and say, they reached a settlement, and it's great, Judge. That's easier for me than having to make those hard decisions.
The other follow-up question I had was with regards to your statement about senior housing being not an option due to the same facility concerns about being the same facility as the still housing, same building. I understand from one of the fancy places in Manhattan that they've actually had separate entrances for the low-income housing. And it's basically a separate building within a building for the low-income affordable housing. And
age restricted the rest of it?
not necessarily age restricted the rest of it, but it certainly did.
You know, here's the thing, the COA rules always required, and I think you would be wise to require this as well, that the affordable units be seamlessly integrated with the other units in the development so that they're not isolated or treated differently. So I think it would be over my dead body as a master that I would allow a developer to create a separate entrance and treat, and sort of, even within the building to separate out the.
Well, I'm talking about for age restriction purposes, because that wouldn't be a possible outcome to the age restriction. I'm very interested in having senior housing.
Yeah, no, senior housing is a good thing. Since I'm a senior, I think it's fine. Let me just tell you that the rules about senior housing are set at the federal level, and the rule to have the state guideline, which is a COA rule, is no more than 25% of your obligation, your real estate development potential can be met with age-restricted housing. But I don't know that the same kind of segregation you're talking about with the affordable units versus the market units could apply based on the federal standards, the federal rules, to age-restricted and non-age-restricted, whether they're affordable or not. It hasn't, so far, it does not appear that that's something that is possible.
And we wouldn't be able to put senior housing in and get credit for senior housing.
Yes, right.
Because our RDP is low.
Right.
So we're not.
I'm not, that was.
But you can't in this context because it's one building. Now, maybe when you go to develop the country club site, maybe there'll be multiple buildings and you could do that. But what I'm saying is you can't have them in the same building. You can't have age-restricted housing and non-age-restricted housing in the same building. That's a federal regulation.
Even if it's a building within a building, like they're divided up?
Apparently not. I mean, we tried this, this was tried in Milltown in Middlesex County, and,
There was a true division?
well, they didn't actually do it, they just proposed it, and, it was researched, and all the legal eagles decided that it couldn't be done.
There were two buildings on the site, not built yet.
You know, in two buildings, you might be able to do something like that.
2.3 acres, I think is achievable.
You might be able to. I'm not saying that that isn't a possibility. I don't think the developer has contemplated that. It's not, it might be physically possible but you would have to do two buildings, and one of them would be one development. Of course he is.
Right, so if he's trying to make money and we get money from the seniors and we want this unit, we always help reduce the number of.
It is certainly something to take to the table. It is certainly something to take to the table and get a response.
Thank you.
No, I mean, mediation is all about taking all the ideas and putting them on the table, and, some of them will stick and some of them won't. So I'm not saying no. You can ask, and we can see what the possibility is of that.
You're next, finally.
I'm Maureen Mike. I live at 270 Forest. Given that this sounds like this is going to happen, it's going to be a strain on all of our resources, schools, public safety, public health, sanitation, all of that. Is there anything in this discussion or this settlement about taxes and what this developer will have to contribute to the town budget? And we're not ever consider restricting that, right? Because we need $20 million for the schools. We gotta, you know, I really would wanna know, is that part of the negotiation? And what is their tax obligation gonna be to support them?
Okay, you can't negotiate taxes, tax assessors set the taxes, but it would pay taxes. And it would even pay them on the affordable units, although they would be valued a little bit less. But it go into the overall, because it's a commercial building in the sense that he will, it's a rental building, it would be calculated probably on the income expense ratio. So he would pay taxes, like anybody else. Now, there is a possibility that I think, if it were a redevelopment site, which I don't know whether you can do that, and I think the council's been a little negative on that, or if it was an area in need of rehabilitation, you might be able to negotiate a payment in lieu of taxes from the developer, where more of what he would ordinarily pay in taxes goes to the municipality, and then the municipality can mark it up with the schools in any way it wants. But I don't know that that's on the table for this so far, but you know, if you think it's a good idea, it can be raised. But I don't know.
I could just say, speaking for the council, every item that you raised are very much concerns of ours from day one.
Yes.
Including the tax impact, including everything else you mentioned. They're of major concern to us.
They've all been on the table.
And we're analyzing them and trying to do what's best for the community.
We're not negotiating tax breaks.
No.
Absolutely. No.
Are you kidding? They gotta get something out of it.
Well, just to underscore on that, we have met as a council with our tax assessor to get from him his insights into the tax aspects of this particular building. So yes, we are pretty well up to date on that.
Hi, Raina Bougele. I live at 30 Forest Avenue. My question is actually very similar to Maureen's. I'm wondering that in this mediation scenario, does the developer have any obligation to fund with taxes on his building the increased cost to the town? Or is it just, are we just at the mercy of, you know, how generous the developer wants to be?
Well, the taxes that he pays go towards defraying, you know, the school costs, because a portion of the tax bill goes to schools.
But is it defraying or leading with the riches?
He doesn't, the tax assessor determines the taxes he has to pay. He gets a tax bill. He will pay that tax bill. What he pays gets whacked up between schools, municipal, county, you know, all the things that everybody else's tax bill gets whacked up on. He is not obligated to actually take on additional school costs. There are only certain things that you can, this is under the municipal land use law. It has nothing to do with Mount Laurel. It has to do with, you know, the municipal land use law. But you can't get payment for, you know, recreation, schools, a new firehouse, a police car. You can't get those kinds of things from developers under any circumstances. What you can charge them for, if there is a public improvement such as the extension of a water line or a sewer line, or maybe some traffic improvements that are in the vicinity of this development and that are necessitated by that development, would not be required otherwise, you may be able to get them to pay for it.
So we said to be expense of school acquisition?
No.
No,
Good luck.
Schools are considered municipal responsibility. Sorry.
Next.
Hello.
Hello.
My name is Adam Ania, live at 9 Midland Avenue, and everyone's actually managed to ask such good questions that my other two questions were already answered. So I have one left. If we were to go forward with mediation, and let's say it doesn't go well, is that something that automatically gets kicked back to litigation?
Yes.
No.
Yeah, the litigation continues. If the mediation is a hiatus in the litigation, but the mediation isn't the end game, only if it results in a resolution of the litigation is at the end game. Otherwise,
Just to put that
Excuse me?
just to put that in perspective, I had mentioned before that at the case management conferences that we have been going to, the judge has been deferring the start of an actual trial. We are in litigation, but we haven't commenced the trial yet. And the judge has put all of these Essex County cases off until April. But he has said that if we cannot successfully negotiate a settlement using the services of the special master. Starting in April, he's going to say you've had enough time to try and settle. It's time now for the court to take over, ask for the recommendation of the special master, either pass on that or go to trial.
So that settlement needs to be reached before the stay?
Yeah, I mean, but I also think that, and we've had this discussion with the special master, I think that if we were to tell the judge that we were very close, I don't think, you know, the judges are looking to try a case that the judge does not have to try. But if, you know, we're very, very far apart, it looks as if we're not going to have a meeting of the minds, I think the judge is going to say, well, look, I've got to move this case along, this has got to be resolved. But, you know, as I said, we've been doing this now for a year and a half. We've had, I think, probably a session every other month, and we've had discussions in between. As has been said, all of the issues that have been raised tonight, including the senior issue, I mean, these have all been addressed. You know, we've had meetings where people left, you know, kind of happy with each other. We've had meetings where we have walked out. We've had meetings where the developer has walked out. We have had meetings where we say we're not going to meet again, we've had enough. And then we've had meetings, you know, through the good graces of the special master. You know, we're talking, you know, we're trying to, but all of these issues are very serious, and they've been raised. You know, we do have the planning experts that support the position that has to be established for the county. I mean, the problem basically is that zoning means nothing, and it's whatever that site will bear. You know, what can we put on that site? And our goal is to reduce the amount that can be put on that site using staff planning principles.
So then, just to follow up on that conversation, who is it that's present at the negotiating table between the town council and the planning board and the mayor and the developers?
Yeah, what we have, you know, we have to be careful under municipal law that we do not violate the Open Public Meetings Act. What that means is that we cannot have participating in any discussion 4 or more people from the council participating, but that would be considered a majority vote, and they cannot be at that meeting. So what we have done is there's a steering committee. I mean, can I mention?
You can.
Yeah, the mayor is on the steering committee, Councilperson Hughes and Councilperson Morrow. Those are 3 members of the municipal steering committee. I am on that group as a borough attorney. The borough administrator is on that group. Jeff Genoda is on that group. There are 6 members of that team that are in contact with the developer and have attended the mediation sessions. What we do, just so everybody knows how, so that the council is fully informed, I do prepare confidential status reports that are privileged legal communication dealing with the status of the litigation. Those reports are sent to every member of the council, so that this is not being done solely by the steering committee. Everybody who is on the council gets those status reports. And as a matter of you know, these things are addressed, you know, concerns that the council has, those are brought back to the mediation sessions, so that we go forward with the steering committee that kind of guides us in between the regular meetings of the mayor and council. But everybody is fully informed of all of the discussions, all of the positions. And I think it's also fair to say that we have been addressed as a group by the developer. You know, we have allowed him to speak to us, to talk to us about what his plans are. We've reached no agreement with them, either just for informational purposes. There have been no decisions made, and as I said, we have no group emails. There are no group emails. I will send a status report out, but we do not have group emails.
Well, thank you for the very complete description.
Mark Keith, 307 Ridgewood Avenue. Two questions. You said high-rise. How high?
What are you talking about, 4 stories?
The original plan is 4 stories.
Okay, that's not high-rise.
It's not actually put right, you're absolutely right, it's not.
And the second question, has it been fully decided that it will be full rental, or is there a possibility of condos or and/or co-ops and then partial rentals?
He has, all that he has proposed right now is a rental building. He has not proposed any other alternative. He builds rental buildings.
Okay, and as a town, have we looked at it, how it would benefit us one way or another, whether or not it was co-ops, condos, or as opposed to full rental? I'm sure we have, but I'm positive.
Yeah, but we can't control it.
Yeah, it's not what we want.
We
He
don't.
control ownership, he
No, I understand
I mean,
that,
ideally
but-
for us, for tax purposes, it'd be best if they were sold as
Okay.
individual units. That would maximize the tax revenue for us.
Okay, so these are things that are being discussed and are on that table of the mediation.
That particular issue has come up maybe a little bit, I mean, it was discussed, but he was pretty clear on what he wanted to do, and municipalities can't dictate a form of ownership, unfortunately. Even in a mediation session, it's hard to do.
Yeah, we're not revealing anything secret. We had those conversations with the developer.
Okay.
Yeah. But we can't control it.
Actually, early on.
Okay.
Yeah.
Even in.
We can't tell him, we can't dictate to him, here's what you have to do there.
Well, if the state can dictate to him that you need to have, if you want to do this and use us as your vehicle to make a profit, because that's what we're talking about here, isn't that in turn an opportunity for us to dictate to him how he meets his obligations for the affordable housing?
Absolutely. With respect to, design issues and, numbers of units and sizes of units and all kinds of other things. But, with respect to the form of ownership, it's a little trickier because it's something that you're simply not allowed to regulate.
Well, yeah, but we could negotiate
No,
with them, but
nothing's
when the
been decided.
negotiation is that we prefer you to build a condo there and have home ownership, we could tell him that, but when in the negotiation process he says, no, I'm not gonna do that, now you have to proceed, one way or the other.
Senior housing.
Right, I mean, these are concepts that we certainly raise. We are very much inclined to present a building for senior housing. We would like to see that happen. We'd like to see people who move out of their homes in Glen Ridge, for whatever reason, stay in Glen Ridge in affordable senior housing. That's a priority of ours. We haven't been able to find a location to do that. Here's something that we have talked with this developer about. It's a part of the negotiation process. But
I will say that there is nothing, even if it's not restricted to seniors, there's nothing that would prevent older people from moving into the building. I mean, it's just not restricted only to seniors.
I actually didn't bring up the senior housing.
No, I know.
part.
You were bringing up the ownership issue.
Yeah.
It's certainly something that, I'm
I
sure
mean,
as a
is there
result
a
of this meeting,
precedent in
they'll
the
hear.
state so far that says that, no, you can't do this, no,
Yes.
you can't make this argument?
No, not that you can't make an argument or make a pitch or discuss it,
Has there been?
but you can't regulate it. I believe there were court decisions, yes, I think, and don't ask me to cite them, but I've been guided by the principle that the judges have decided that you cannot dictate ownership. Somebody can't tell you, for example, whether you can rent your house or
Someone can
sell
tell
it.
me that if you come into my town to build for profit a 125-unit apartment complex, right, because they're using a tool that the state court has given them.
Yes.
An economic incentive to do so. So if they can come in and tell me that, why can't we go in and direct them to, well, if you're going to satisfy this requirement, we would like to see you satisfy it in this way. If the purpose is for the state to increase fair housing, how it gets there, if we have an alternative that gets the same advantage to the people that we're supposedly helping out.
It actually doesn't.
Our interest
Yeah.
is as important, if not more, than his economic.
Well, it is absolutely important, your interests are absolutely important, but let me tell you another thing that I probably have not emphasized, and that is that just as there is a limitation on how much of your obligation you can meet with age-restricted housing, there is also a minimum requirement that you meet at least 25% of your obligation with rental units, and at least half of those have to be available to families. So that means that the first thing you have to look for if you're going to meet that requirement is a rental project. So he's got that going in his favor. And you can't, I don't think you can mix it in a building, can you?
You can in New York, I don't know about in New Jersey. I'm an old New York State property attorney, so my ignorance on the New Jersey law is best, and I plan to keep it that way.
I don't blame you.
But these are, thoughts that just occurred to me, that,
Okay.
look, he's here to make $1.
Yes, he is. No
so
question.
Is there a way for us to push him in a direction that he can make his $1, but we can be protected in ways as well? I mean, I'm in this town for the next 18 years at least. I've got twins that are 3 years old, and I have a 5-year-old.
Wow.
So this all is very, very important.
Well, all I can say is, I think that the council is hearing your issues, and they will go back to the table with those issues.
And as far as mediations, that's what I do for a living.
Do you really?
Have fun with that.
Sometimes it's fun, and sometimes it's bad.
Make it a one-bedroom, two-bedroom, three-bedroom, they join in,
Anybody else that wants to be heard?
whereas if it's a rental, it's restricted by the deed. Should I raise that point?
Again, did we stumble into this because of this developer? If those 4 families had not decided to sell and remain single families, would this be not an issue?
No, it would not be an issue if they had.
Absolutely not.
It's
Okay.
5, Cherry, it's 5 properties that are
Or
there.
5
He's got 4 already
Okay, well,
under,
it started off fewer.
Right.
And the units were, as originally stated in the Glen Ridge paper, or the Voice, 59 units,
Right,
with 9 low income.
right.
Suddenly, it's 125. And what if other developers turn around and find other houses? Have we tied up our zoning? I mean, what?
The vehicle for tying up your zoning is to settle the case and get a judgment of compliance and repose.
Right. Because zoning doesn't
That's
protect
the
us.
vehicle for doing it.
Zoning does not protect us in this instance.
Right.
And of course, I thought that the historic districts would protect tearing down senior or single-family houses. Clearly, it doesn't.
Well, we've had tear downs in the past. To the question that was raised about, I think it was the ex-attorney from New York. What?
Still an attorney. In mediation.
My understanding is that if these were sold as, say, condos or co-ops, then the owners would have the opportunity to change the footprint of the unit, and maybe even buy adjacent units and make them larger. Whereas if it's a rental, that's not the case.
But if you're using it partially condo / co-op, just
Yeah, okay.
condo, and then another part of it, say 25% of the development is rental units, and of that, that's where you end up with your affordable housing. I'm not sure.
Right. I mean, one of the discussions that we've had, at the risk of, Mayor, if I may, one of the discussions that we've had is that we're in discussions with the number of units and the and the layout of each unit, and putting restrictions in as to how those units may or may not be changed into the future. And one of the things we're looking at is to have the building inspector
Well, actually adopt an ordinance requiring certificate of occupants when there's a change in rent.
Right, so if there's a change in renter, they would require a certificate of occupancy, which would then trigger the building inspector to go in and make sure that that unit has not been altered in any way from the original footprint. So that's one of the things that we're looking hard at, to try and protect ourselves from changes.
Well, that doesn't usually necessarily happen too much in rented units. That would happen more so in the common.
Which is our point. So while there's an advantage tax-wise, if we were if this were to go as a for sale building, there are potentially disadvantages if it goes for a for sale building. So those are the things that we've been looking at.
And once again, it wasn't so much so that it would be only a for sale units, it would be a mix.
And again, I think to the special master's point is that we really can't dictate to the owner or developer as to what he's going to do with that, whether he's going to put them up for sale or what he's going to rent. And I don't know if he can do a mixed situation where he could rent some and sell some.
I don't actually know.
I think he can. I mean, I think that's been done over at Maxwell's Mills.
I think it has been done in various places. I think it's possible to do something like that. But I will tell you that, you know, in the, it was interesting because there was a West Windsor decision years ago in which kind of worked the other way. The developer wanted to do apartments, and the developer had originally asked for apartments, and then he wanted to change his mind and do single-family homes, and the town wanted the apartments because they were going to get more affordables out of them, but the developer wanted to do single-family homes, and the judge said, you have to allow the developer to respond to the market. And at that point in West Windsor, that's what the market was single-family homes. So, basically, the judges, particularly in inclusionary developments, which are developments that include some affordable housing, will basically uphold the developer's right to respond to the market.
Well, I like that one.
Did you have something?
Because quite frankly, this market for 1 to 2 bedroom units kind of would be for people that want to stay within the community, that are looking to get out of the house that they've had for years.
Mm-hmm.
I wish it had been around a couple of years ago.
Did you have a question? I'm sorry.
I guess when you're done with this.
I think we're done.
The only thing I was going to say was, the comments that have been made are obviously going to go back to the developer. I mean, they'll be reflected back. So, they will be part of the discussion.
Hi, Rebecca Mitchell, 100 Forest Avenue. I just wanted to bring up one thing that was one of my concerns that I didn't really hear addressed here, and that's all the kids that are in those areas, at that little school that's there and at the field. I know I've been over there trying to pick my own kids up, and you have kids running across the street and tons of cars, and I know we share that field with Montclair, and are they going to be involved at all in giving their thoughts, because their children are going to be down there too, and I'm not sure what the story is with the school there, but they're certainly in that vicinity.
I will tell you that, I don't know so much about the role of Montclair, but I will tell you that a big issue in the mediation discussions has been traffic, parking, driveway access because of the school and the playing field.
And safety at George Washington
The
Field
public
is across
safety.
the street,
Yeah.
with Minnie Lucy School.
That has been as important as any other aspect of the discussion.
Well, this is,
Yeah, no, everybody here shares the same concern that you've expressed, and that has probably been the one thing I've heard most,
well,
in connection with
this situation is really exacerbated by an unknown, and that is that if we go ahead, or Mountainside goes ahead and builds the medical office building, it's going to bring in a tremendous influx of traffic. And that's going to be added to this, and this is what gives us a lot of concerns because of the amount of children that are getting in and out of cars there, the fact that they're parking along the streets, even though I am assured that street is width of, over 30 feet? Over 35 feet, so it's a standard road. It doesn't look like that when you have all those cars and people letting off kids. So, yeah, it's a lot worse than just taking into account this one apartment building we're talking about. We're talking about a buildup of in several areas there. So.
Just starting over to get a soda.
Right,
selling across the street.
Yeah.
But the special master herself walked the site
Yes, I have.
and is familiar with the
With everything that's
location
around.
and the school and the playing field and the bridge and the hospital location. So the Special Master is well aware of what's going on at the site and the potential development of the site. And to my understanding, does not feel that the site is unsuitable as a result.
No, it's not unsuitable, but there are certain things I think are important, like they provide all the parking they need on site so that you're not gonna have on-street parking from these uses because, you know, that's gonna interfere with the use of the on-street parking for the field. And also location of the driveway. There are a number of things I think are really valid considerations that you need to deal with. I mean, because it is an awkward intersection anyway when you come up to it. So, no, I mean, these are issues that I think have been discussed a lot, and we're hoping that the developer will respond, you know, in a positive way to them so that you can, because I don't think without some sense, some comfort level, I don't think there will be a settlement. Since I want a settlement, I'm leaning on the developer a lot on that too, so.
Thank you.
Thank you.
If I can make a point, Mayor, we're negotiating, and he's not controlling the negotiations. We're looking for things. We're trying to serve the community the best way we can. So he's got to give. Sometimes we got to give, and you try and work it out. But if we can't work it out, then we go to trial.
Right.
And then
The
you heard what could happen at a
definition of
trial.
a settlement is where nobody gets everything they want, but everybody feels that what they ended up with is better than what they could have gotten had they ridden it out to trial. I mean, it's just, you get the best you can under the circumstances. So we don't know what the best you can is yet, and we'll, you know, obviously, you know, your representatives are gonna keep trying, and so is the developer. I can guarantee he won't give up either, but, you know, somehow I'll have to try to bring them together. It's my job.
I know, and I just wanted to bring up the point about the other organizations that maybe had some concern.
Thank you.
Thank you.
Thank you.
Thank you.
Anybody else?
Mayor Patrick, you had discussed working with the tax assessor, to evaluate what the taxation on the 2.2 acre plot of land might be once developed. And have you considered, obviously the proposal is for rental, but have you considered different tax consequences if it were to be mixed rental and, owned or all owned?
No, I don't think so. I think that we are pretty much taking the developer at his word that he wants it all rental. I don't think that that's, correct me if I'm wrong, John, I don't think that we've ever considered a mixed, especially along the tax aspect of it.
That's correct. We've only looked at it as as if it were a rental operation. And there's, John, two ways to look at it, right, in terms of evaluation. And we think probably most likely one is going to be an income and expense approach based on the advice of our tax assessor.
Yeah, the other thing I might add too, Mayor, is that, you know, while we've had this discussion with him, I think one of the things that we have been concerned about is that whatever is built there is of a quality that will be something that Glen Ridges will be proud of. That's going to be quality construction, and I think that's always been a concern. And I think that in talking about this, that if it's an apartment building, then there is, you know, one person that you look to who's the apartment owner of the entire complex. And I think it's somewhat easier sometimes to maintain those controls when you're dealing with one person who speaks for the whole building, rather than if you had a situation where there were multiple owners and you run into different sorts of problems. But I think first and foremost, it's the quality of the project that we're looking to. I mean, certainly all the other issues, but when it's all said and done, you know, we want this to be something that will be representative of Glen Ridge in its quality.
Is our only leverage the builder not wanting to go to trial? What is our leverage in mediation?
The leverage is that if he gets a settlement with you, there will be more cooperation when he gets to the site plan stage. Things will go more smoothly. So he's willing to work with you just because it's going to result in a faster outcome. If he goes to trial and he gets a builder's remedy that you can't live with, you'll probably appeal it. You won't necessarily win the appeal, but that's years, when you start going through the appeal process. That can be years, and it's very costly, and he's got to pay the carrying charges for the land. For a developer, time is money. So he believes this is faster, even if he has to give up some units, even if he has to do things your way and not his way, he's likely to be able to get in the ground sooner. So that is actually a big incentive for a developer.
Isn't there a thing with depreciation so that the developer or owner every 20 years or whatever it is then sells, such as Parkway House, which was originally built when we moved into town for senior citizens to keep them in town, and now there are children in Parkway House?
This building will be subject to a deed restriction that will require at least the affordable units to be maintained as affordable units for a period of at least 30 years. And here's the thing, even though the developer's lawyer will probably scream and yell, but the Uniform Housing Affordability Controls would now have that deed restriction continue until the municipality elects to remove the restriction. So it might be a lot longer. I expect that when that deed restriction is over, I'll be dead. But in any case, it will be under the deed restriction.
Isn't that true about depreciation and the tax deal?
It can be, but that's more for tax purposes than anything else. But, he could possibly, at some point, I suppose, decide that on the market units he wants to condominiumize them, but he would still have to maintain the affordable units as rental units if that was the agreement. He could decide to do that. There are things that he can do. Again, that's something the municipality can't control. They can only control the affordable units. The affordable units will remain exactly as they were intended to be.
You have a question?
We talked about the builder's exposure and his intents for going forward for getting mediation. What really, if we can delay this by 5 years and we're just exposing ourselves to a few $100,000 in legal fees, what's our incentive to go forward and mediate this? It seems to me that the land just wouldn't exist for more than 125 units maximum.
I wouldn't be so sure of that.
Is that possible? What's the over-under on more than that being approved?
I don't know. Nobody has shown me a plan for more than 125 units, but it is certainly physically possible to do anything. If you go up in height from what he's proposing, as long as you can meet parking, he can structure parking. There are a number of different alternatives. Let me just tell you that in all the time, and I've been doing this for quite a long time, I have not seen densities go down in terms of what developers ask for. I have not seen properties that are deemed to be not particularly suited for development 1 year will surface again 10 years later. It's still the same properties, and their developers always asking for more. So I think that, first of all, you won't be allowed to continue this indefinitely for 5 years. You won't be able to just roll along with it. The court will ultimately make a decision. So that isn't an option, really. But even if it were to seem like an option, I don't think in the end that you'll end up in a stronger position. You're in a stronger position if you work out a deal with the developer. I know it seems like you don't want to sit down and talk to a developer that sued you, but it is how you will get more of what you want as a community. I know that, for a lot of people, and almost always when I start mediation, both sides have to air their grievances with each other. The first session is usually not very productive because everybody's mad that they were sued and everybody's mad that the town didn't roll over and give them what they wanted in the first place. So after that's out of the way, then you can begin to talk about, okay, what can really happen here? What are your issues? What do you need? What do you need? And you start to put it together. you know, there isn't really an option of waiting 5 years and hoping this will go away. It's not gonna happen, because you're in court now. Well, these judges are supposed to be settling these cases, or handling these cases quickly, I mean, resolving the cases. So whether they are adjudicated or whether, you know,
Maybe we could upset them, maybe.
there may be other repercussions that you don't like about that, but,
You're gonna pay
and
for both sides of it.
he has reasonably deep pockets.
Yeah, excuse me, I mean, that is not a good comment, because it is fee shifting. So you hold him up and the court orders you to pay his expenses. It isn't a couple $100,000, it's multiple that.
Yeah, that's probably true. In a case like that where you were deliberately holding him up, you would probably look at fee shifting.
Has there been any precedent on that to say this type of case results that appeal or these decision before the trial court, right? Superior Court?
It's in the Superior Court right now.
Taking the television, is there a precedent that says that fee shifting has applied to this type of case in New Jersey?
There are cases where there has been fee shifting. It's often when it goes up on it's going out of my head, the kind of trial where it's a civil rights, when a civil rights complaint is added, which would happen if you dragged it out. And then you can have fee shifting.
Complaint would be filed by the developer?
Yeah, in a federal court. So it could happen. You know, I mean, the point is, it's an unknown as to what a judge would actually do. I can't tell you that, yes, if you do this, you're going to be paying a fee. I don't know that. But it depends upon, you know, what issues are raised by the developer, and it depends upon where they're raised and what that particular court does with it.
So the fee shifting, was that only for the removal to the district court, or was that for the state proceedings as well?
I have seen fees paid in some cases, even in settlement contexts, I've seen some fee shifting. But it's rarely used. I'll be honest with you, it's more rare, but you don't want to make yourself vulnerable to that, because you can't control what the developer says his costs were.
Okay, I think that it's now 9:45. I think we've exhausted most of the subject. To the extent that anybody still has questions, please feel free to call anybody that was here tonight, like Mike Rollhall or myself or Jeff, and get your answers. But I think at this point in time, we should just end it. Betsy, thank you very, very much.
You're very welcome. I have to say, it's actually been a pleasure, because the questions were really good, and you all seem to know what you're talking about. Obviously, you're all prepared, and you know, you read through stuff, and so it's been a pleasure. Thank you for inviting me.
Thank you for coming. We're at least passionate about our town. Unless people want to see the rest of government in action, you might want to take your leave.
Thank you for your question.
And I would like to propose a 5-minute break, because
I need a glass of water. I need anything else?
Jeff, thank you.
Thank you.
It's not going to go away.
Yes, no, definitely, all of the questions have been.
Do you want some water? You sure?
Allow more homes to be available to I still think it would be great to pursue that two-building idea or building You don't know what you're It is. And that, they can make it a lot. Well, good luck.
Well, thanks for your time.
And it borders the old railroad. No, she's always been an advocate for she maybe you
Yeah, no, I know.
I'm not the only one speaking.
I'll start with that. Okay.
Thanks for coming in. Thanks for your time.
Thank you.
And Mike has
Oh, good.
where I started, where
Well, no, this is the most important.
Well, if this thing goes forward, both entities will be taking a look at it.
Okay, we'd like to reconvene this meeting.
Do you have the proclamation? Do you have the proclamation?
We're going to pass that. We need to get it upstairs. Should we start without Art? We can, we got a forum?
We have a form, if you want to go, we could go to the hearing for CDBG.
Yeah, okay, there are no more comments of the public, so there are no comments of the mayor, so we will suspend the regular order of business to conduct the second of two public hearings on suggested application projects for the 2017 Community Development Block Grant Program.
Thank you, Mr. Mayor. This is our second of two public hearings for a Community Development Block Grant Program, also known as the CDBG program. CDBG funds may be used to serve the low to moderate income population, as well as seniors and the disabled. Applicants are required to present the proposal in a public forum. The council is to review these proposals and present a resolution ranking the applications. The applications are then sent to the Essex County Office of Housing and Community Development for final review. The Essex County Office will then announce the grant award. The notice of awards has not been established. At this time, I ask that any applicants come forward and present their proposal.
Are there any applicants here for the CDGB?
Mr. Mayor, on behalf of staff, we have a proposal to make ADA improvements in the northern section of town, especially around Forest Avenue, School, the Stonehouse area. There's no access to the Stonehouse Road currently, so we're going to be doing ADA grants there, as well as possibly Cambridge Road and a few other roads in the far northern area of the borough. So that would be staff's recommendation.
Okay. Are there any other applications? Seeing none, what is the procedure now on your
At this
application?
time, if the council approves, we have a resolution prepared on the consent agenda to continue the ADA compliance program.
Yep.
Thank you, Mr. Mayor.
Thank you. I see it, 138-16?
That's correct.
Okay. But it will be part of the consent agenda?
That's correct.
Okay. Councilman Hughes, you got something for us this evening?
Mayor, I have no report tonight, but I do have a number of things to put forth for vote. I have a consent agenda, resolutions 133-16 to 139-16. The following items are considered to be routine and will be acted upon with a single motion. If any discussion is requested on a consent agenda item, it will be removed from the consent agenda to the regular agenda. All consent agenda items will be reflected in full in the minutes. So, Mayor, I move the consent agenda resolution.
Do I hear a second?
I second.
Thank you, Paul. Any comments on this? If not, will the clerk please call the roll?
Councilperson Hughes.
Aye.
Wasovich.
Aye.
Leftwich.
Aye.
Dawson.
Aye.
Murphy.
Aye.
Morrow.
Aye.
6 ayes, no nays. The consent agenda is approved.
Thank you.
Mayor, I have ordinance number 1650, an ordinance authorizing salaries for CWA employees for final reading.
Mr. Mayor, this is state for record that this ordinance has been properly posted and advertised in accordance with the state statute.
I declare the meeting open for discussion of this ordinance, and only this ordinance, this being the time and place for the public hearing. Does anybody wish to be heard? Seeing none, I declare this public hearing closed.
Mayor, I move that this ordinance be finally passed.
Do we have a second?
I'll second.
Thank you, Arnie. You have heard the motion of Councilperson Hughes, seconded by Councilman Dawson. Will the clerk please call the roll?
Councilperson Hughes.
Aye.
Wasovich.
Aye.
Leftwich.
Aye.
Dawson.
Aye.
Murphy.
Aye.
Morrow.
Aye.
6 ayes, no nays. The ordinance is passed on final reading.
Thank you.
And Mayor, I have ordinance number 1651, which authorizes the 2017 salaries for exempt employees for final reading.
Mr. Mayor, this is state for record that this ordinance has been properly posted and advertised in accordance with the state statute.
I declare the meeting open for discussion of this ordinance, and only this ordinance, this being the time and place for the public hearing. Does anyone wish to be heard? Seeing none, I declare this public hearing closed.
And Mayor, I move that this ordinance be finally passed.
And I'll move to second that.
Thank you, Paul. You've heard the motion of Councilperson Hughes, seconded by Councilman Pasovich. Will the clerk please call the roll?
Councilperson Hughes.
Aye.
Pasovich.
Aye.
Leftwich.
Aye.
Dawson. Aye. Murphy.
Aye.
Morrow.
Aye.
6 ayes, no nays, the ordinance is passed on final reading.
Thank you.
Mayor, that concludes my report.
Thank you, Peter. Paul?
Mayor, I only have ordinance number 1652 for first reading. This is an ordinance establishing titles for the employees of the Borough of Glen Ridge represented by the PBA Local 58 and fixing maximum salaries and other compensation for those titles.
Do I hear a second?
Second.
Thank you. Peter? That was it?
Yep. Yeah.
Sorry. Any discussion among the members?
Yeah, this sets simply the salary structure in our police department, PBA employees.
Will the clerk please call the roll?
Councilperson Hughes.
Aye.
Pasovich.
Aye.
Leftwich.
Aye.
Dawson.
Aye.
Murphy.
Aye.
Morrow.
Aye.
6 ayes, no nays, the ordinance is passed on first reading.
I refer ordinance number 1652 to the municipal clerk for the purpose of statutory publication and posting.
Yes, Mr. Mayor.
And that's all I have, Mr. Mayor.
Thank you, Paul. David?
Mr. Mayor, I have no report this evening, but I would just like to use a minute of time to say two related things. First of all, to compliment our borough attorney on a really thorough and excellent letter, and also secondarily to compliment Councilman Murphy in his moderation of the considerable Facebook discussion of that letter. And I think the letter and what I thought was an unusually nuanced discussion of it on social media, I think both contributed to, first of all, to the large turnout that was here. It's a very important issue, but also to the informed and educated tenor of the discussion that we just witnessed.
Yep.
In spite of the late hour, I have to say it's one of the best meetings I've ever been a part of, and I'm actually very impressed with how the public conducted themselves in terms of being well informed and on point. So I think some of the credit for that has to go to the information that they received and the way that that was moderated in public. So kudos to you.
Well said.
You're here. Yep.
Yep.
I have John looking over my shoulder quite a bit.
That's okay.
Art, you up?
Yes, I have a brief report from Public Works, and I also have 2 resolutions that I'd like to offer tonight.
You do? I'm sorry. I don't see them.
I don't think you do. They're here. I have them right here.
I think,
12816 and 128.
no, I think those are from the last meeting. I think that's the last meeting packet.
Oh.
Yeah.
Oh,
Yeah, we're on
right.
139.
You going rogue on us?
Huh?
Are you going rogue?
At this point, you should say, never mind.
Try to catch up with us, Art.
I didn't look at the date at the top. It was just here, and I figured it was okay.
It's
All right.
that trip to the North Pole that got you.
All right, the report I have for the Public Works, our crew spent time breaking down and cleaning up in the Ashenfelder 8K run and getting ready for the Borough Tree Lighting Celebration, both of which the run and the tree lighting went off very nicely with good crowds. And again, Dan Murphy, I think, deserves considerable amount of credit for the organization for the 8K run. It was very successful again, and it was a good turnout.
Thanks, sir.
The DPW group has been cleaning up our parks and repairing them for winter. The sprinkler systems have been blown out and winterized. With the temperatures getting below freezing, our team has been removing gator bags from around the street trees we planted this year. All of our winter equipment is in good working order. We had our first taste of winter and ran our salters through the borough last night without incident. In anticipation of this recent storm, we also sprayed brine on bridges and hills, so that system is working well for us. Our salt shed is well stocked, and Public Works is ready for winter. So that concludes my report.
Thanks, Art. No resolution?
No. We did that already.
Dan?
Thank you, Mr. Mayor. I wish I was as ready for winter as DPW is. A couple things. We fixed, remediated major construction to the baseball diamond at Burrell Field. Looks great. We've got it fenced off, so hopefully it'll look good in the springtime when we open it up for play. And if you've been to Carteret Park, perhaps you've noticed we have new light fixtures that replaced some of the light fixtures that were broken. They're smaller in scale. They look really nice, and I thank Mike Zucchelli and Mike Warhol for finally getting that little project complete. That's it. That's all I've got. Thank you, Mr. Mayor.
Thanks, Dan.
I have one other thing I
Sure, go
meant to raise. There's been some discussion about whether or not the TV thing on the channels has been entirely legible or not. Would you look into that, please? Whether the audio.
Audio is not very good on the channel.
In general or during the meetings?
During the meetings.
I got your sound system.
No, I mean in general, not from the meetings when they rebroadcast.
Right. That'll be part of our 2017 budget appropriations. We're looking at.
Fantastic.
We've been working with Rich a number of years.
Yeah, we feed right off your microphones directly to the
we, yeah. The only way to improve is to upgrade our system, so we have that as part of our 2017 budget.
It's very hollow sounding if
Yes.
you've watched it. I mean,
It's not balanced.
it's almost impossible to
Part of the
discern.
problem, just to get that for a second, those microphones there, you have to actually speak it. So when you turn the face command,
Right.
you've got a side sheet or something for those microphones, they're not optimal. The old ones used to be unidirectional, but they weren't the best either, so you guys not.
Because the other problem is when we turn, of course, to speak to somebody in the audience, we lose the vocal. So we're aware of that problem and we're going to upgrade in 2017.
I want to also thank Rich Waters for his continued service running this thing. Appreciate it.
Absolutely.
Yes, thank you.
Thank you, Rich.
Hey, Michael, as part of that project, are we going to include actually getting 21st century air conditioning in this,
We have prices
this
for
room?
you.
Okay.
Think about
That's
spending
what I
money.
heard, that's what I heard in 2014, 2015,
Remember we gave you the
2000.
proposal. It went down.
Okay, all right.
It has to go through the finance committee.
Enough said.
We could take it for the public safety budget, we'll do that, Paul.
Don't let them sit next to each other.
You can come in on Saturdays and knock holes in these walls to put the ducts in.
Yeah, the problem we had is we were working on the aesthetics, the way that the HVAC engineer had proposed, and we thought really more the look of the council chamber, so we're working with another designer on trying to come up with a scheme.
Yeah, I mean, I'm serious about, though, getting those hotel type.
That's what you're saying, the way we're mounting them,
Quiet.
we didn't really care for, so we're looking at a more aesthetic solution than that was given to us.
Okay.
Anne Marie?
I have nothing. Thank you.
Great. Comments of the administrator and department heads?
Just one, we're going to be making some lighting upgrades. As you know, a couple of years ago, we upgraded the lights on Ridgewood Avenue, the 200 light. We're going to be doubling the antenna lightage there, and also
Nice.
we'll be installing lights on Woodland Avenue. So we're working with PSE&G. They said it's in the pipeline, so we want to upgrade on both Woodland and Ridgewood between Bloomfield Avenue and Snowden.
Are you going to use the fixtures that were approved by the Historic Preservation?
Correct, that's correct.
They're quite nice. I mean, I think it'll integrate nicely to the whole street.
The streets, and also a concern just with the pedestrians.
Absolutely.
From the train station. So we wanted to bring up the illumination in phases, so we felt it's ready to double it again.
Maybe we should get some more of the four-mantle gas lines instead of the three to twos.
That's true. Yeah, because this is my report, Mr. Mayor.
Thank you, Michael. John?
Mayor, the only comment I'm gonna make on the builders remedy lawsuit, since we've had such a long session tonight on this, is that I think that, the mayor and council made a number of very important strategic decisions in the conduct of the litigation. And when we were first sued, we all identified this as a very credible and as a very serious matter. And when we were sued, we were in a standalone proceeding. It was the developer against the borough, but we were not part of any other group. And you may remember that we had the opportunity to become part of the consolidated proceeding. And, the mayor and council affirmatively thought that that would be something that we should do, and we did do. And we also opted affirmatively to engage the offer of the court to have a special master. And that's how we wound up with special master, Betsy McKenzie. And, in addition to that, the mayor and council made a decision to be part of the New Jersey statewide consortium. And that made available to us, many of the briefs that were filed in other jurisdictions. We get status updates, which, we circulate, to privileged correspondence. You can follow the proceedings of the New Jersey Supreme Court to the effect, to the point that it affects us on issues of that. So, we made, I think, all of the right decisions to participate as best we can, with the end result that whatever happens to us, it will happen to us with the assurance that, we will not be treated any differently than any other New Jersey municipality, that we're all in the same boat. It's not a boat that anyone wants to be in, but I think certainly wherever the boat is going, we're better off being with the group than if we were on the sea alone. I think that would have been not a good thing.
No, I think it certainly wouldn't have been very cost efficient.
Yeah, and I think that the mayor and council, like I said, have really made, the right decisions to be part of all of these different groups that we can avail themselves. Our expert, for the fair share number, it has been very, very helpful.
Thank you, John. Captain? Chief? Sorry, you just got demoted.
She wishes she was that age again.
Just wanted to remind everybody in town that we're participating this month in the state program called Check Your Vital Signs. It's for not only drivers but also pedestrians, and it really is for safety. Intersections and crosswalks. The officers will be doing it for the entire month, giving out pamphlets, warnings, summonses if necessary, and we've earmarked the two intersections of Bloomfield and Ridgewood, and also Darwin and Ridgewood for the month of December. And we've certainly asked the officers of the other intersections that they really think we need to hone in on, but we're going to put most of our concentration there for this month and see if we can work with drivers and pedestrians.
Right. Is there any new or unfinished business?
No, Mr. Mayor.
Comments from the public? Anybody wish to be heard?
Thank you, thank you.
Okay, seeing none, Paul, you
I
have
would move
most...
to adjourn the meeting, Mayor.
Second, all those in favor?
Aye.
Aye. Adjourned.
Good meeting, Mayor.
Hey, Dan?
What's left of our evening?
Oh, this is nice, look at that. It's good mayor, buddy. Good meeting, Mayor.
Oh, look at this. I have the wrong record, right? Are you going to be free on Friday? I know they're having lunch here, but maybe an hour before. Absolutely. It's pretty simple.
The first mile was great, and
I'm ready to go.
We all are.
Good meeting. People weren't hysterical, they were, they were thoughtful.
Absolutely. Spend all day, and it's actually perfect. Swear in, and instead of bringing them over here at 2:30, it's going to swear in Abrahamson at the town luncheon, and also Ryan Schwartz, both effective for January. So it's done now.
Yeah, because I'm going to meet with him after.
At your convenience, you tell me.
Before lunch, do you want to be free? I figure this is easier.
That's perfect. Yep. Sounds good. Great. Thank you.
I pulled them in the back so that they wouldn't, and they're stolen in 1 week. I'm going in as, I'm going to rob this gavel. I want to report a theft.
You always want it, right?
Can I report a theft?
Go in outside my
I understand the judge has been stealing my pens. And they only been there for a week, so.
I was trying to steal anybody, so I got it, and I was like, oh.
I think she's trying to tell me she's not going to take the complaint.
Mike, do you need anything done?
No, I'm good, safe, thank you.
All right.
beat the judge no matter where you go.
Michael, these are your glasses, right?
Yep, those are all mine, that's my packet.